Hi, good morning. So today we'll be covering parts of our presentation will be on the impact of 2019 amendment on a Section 11 petition and how going forward, how it has to be filed, where it has to be filed, and what will be the impact thereof. And we'll be covering the impact of Section 16, basically when you can raise a jurisdictional challenge before the arbitral tribunal, what is the scope of the challenge that can be raised, and aspects on non-binding term sheets if they have an arbitration clause, and whether non-signatories can be added to an arbitration proceeding. So I'll be talking about the amendments shortly, only covering the impact on Section 11 and not going beyond that. Basically, what the amendment seeks to do is it plans and seeks to align Indian arbitration situation with the institutional arbitration mechanism which is there in Singapore and Hong Kong. Statistically, it has been reported that India is not great when it comes to arbitrations and alternative dispute resolution system. So there were Law Commission reports earlier which recommended that institutional arbitration mechanism should be sort of inculcated in the Indian dispute resolution domain, and that's why we have amendments to Section 11. Now, Section 11, there's a new subclause inserted, which is 3A, wherein the Supreme Court or High Court both have been given powers to designate arbitral institutions on a graded mechanism in consultation with the Arbitration Council of India, which will have a seat in Delhi. And these arbitral institutions will be the place where an application seeking appointment of an arbitrator has to be filed going forward. So basically what the amendment does is it has replaced the power of a High Court or a Supreme Court, and that power is vested with the arbitral institution. In the event the Arbitration Council of India, which is supposed to be set up under 43A, has not graded these institutions, what the courts will do, they will have a panel of arbitrators which will act as arbitral institutions, and those panel of arbitrators will be the ones who will deal with the application for appointment of arbitrators. Now, the point of contention here is that the amendment has removed subclause 11(6)(a), which limited the power of courts in determining a Section 11 application only to existence of arbitration agreement. Now that that subclause has been removed from the section, it's slightly ambiguous as to what will be the scope of the arbitral institution, whether the arbitral institution will limit its jurisdiction in terms of dealing with such applications only to existence of arbitration agreement, or will it go into validity of the arbitration agreement as well. Now, going by precedents, there are judgments in place which talk about the principle of competence. Competence, basically, the arbitral tribunal only has competence to adjudicate upon its own jurisdiction and whether the matter can be taken, whether the matter can be carried forward by the tribunal. So going by that principle, these these institutions should not have powers beyond adjudicating upon the scope of existence of arbitration agreement. However, once the institutions come into place and we have rules on gradation, we will have more clarity on how the functionality of these arbitral institutions will be governed. Another amendment to Section 11 is the disposal timeline. Earlier, as per the 2015 Amendment Act, timeline given to the court, Supreme Court or High Court in the respective cases would be 60 days timeline. Ideally, these petitions should be disposed of within 60 days. But currently with the amendment, it's shortened to a 30-day timeline, which is further expediting the process of appointment of an arbitrator. Another aspect of the amendment is, another aspect of the amendment is that it doesn't put a maximum cap on the number of arbitral institutions in India. Now, with in a country which has 24 high courts and 1 Supreme Court, for each of the high courts to come up with designated arbitral institutions and rules thereof may create some bit of confusion and may sort of create confusion in terms of application of those rules of the arbitral institutions. Now, the fundamental flaw which lies here is while we have picked the mechanism from Hong Kong and Singapore, all of these jurisdictions have a central arbitration institution, whereas the same thing has not been inculcated in the amendment. So we will see how the arbitral institutions functions once they are graded and once they're established pursuant to the Amendment Act. The important aspect of the amendment is what will be its impact on ongoing Section 11 petitions. There is lack of clarity on this aspect as of now because the amendment doesn't have any cutoff date from which it will be applicable or what will be the impact on the ongoing proceedings. However, there have been decisions in the past on 2015 Amendment Act and the applicability thereof, which can have sort of guidance when we are interpreting and applying 2019 Amendment Act. So the decision which will be helpful in this aspect will be the BCCI versus Kochi decision, where the Supreme Court held the 2015 Amendment Act will have retrospective application if it covers the procedural aspects of the law. And the specific decision in case was dealing with application to automatic stay of the award. Now, what had happened with the 2015 amendment was that there was a new provision inserted where under 34, it clearly stated that there would not be any sort of jurisprudence where an award would be automatically stayed. And if a party wanted the award to be stayed, they would have to move a separate application under 34, and thereafter that has to be argued before granting a stay on an award. But prior to 2015, the jurisprudence was that automatic stay would be granted unless and until the execution is finally allowed under 36. Now, later on, BCCI formed the judgment on this aspect of how 2015 amendment would apply on field, basically clearly stating that procedural aspects would have retrospective application, but any sort of substantive change in the law will not have any retrospective application. Now, with the 2019 amendment, the legislature inserted section 87, which stated that unless otherwise agreed by the parties, retrospective application will not be there of the 2015 amendment. While the legislature brought out a specific section to clarify position on 2015 Amendment Act, they somehow forgot to insert a provision to clarify the applicability of 2019 Amendment Act. So post this section, again, the amendment was challenged, and the Supreme Court, in its decision in Hindustan Group Companies case, invalidated the section inserted by the legislature, and it held that section 87 itself was arbitrary because it tried to overrule the judgment which had based its ratio on solid jurisprudence in terms of how procedural law should apply and how substantive law should be applied. Now, in the absence of any such proper sort of reasoning given by the legislature, it didn't make any sense why section 87 should be kept in place and why an amendment which is procedural nature cannot be retrospectively applied. So this is one judgment, and in fact these two judgments, reading of this shows that generally courts will allow application of any amendment retrospectively if it has a procedural change. But if there's a substantive change which is brought in place, then they will not allow retrospective application. Now, there are not many decisions which have basically judged on the merits of a Section 11 application and what would be the status when 2019 amendment are applied thereof. But there are two decisions, one of the Delhi High Court, one of the Bombay High Court, which generally propound on the principle as to how 2019 amendment will affect ongoing arbitral proceedings. There is one decision of Delhi High Court of Justice Midha in Shapoorji Palonji case where they talk about application of the limitation aspect under 29A. Basically, under the 2019 Amendment Act, the timelines for completion of the arbitration proceeding and writing of an award in case of domestic arbitration and international commercial arbitration have been changed. Now, what the court held is that this limitation aspect or the change in timeline is a procedural aspect, and therefore it can have a retrospective impact. Also, what the court kept in mind was that earlier under the 2015 amendment system or prior to 2019 Amendment Act, parties would have to move in applications after completion of, say, 12 months of the arbitration to seek an extension. Sorry, after completion of 12 plus 6 months, they have to seek an extension from court, and the court depending on the reasons given in the application, would allow or would change the arbitrator appointed if the court sees that there is no reasoning why there should be an extension. So to keep this sort of system aside and reduce the judicial intervention, the court has also interpreted that 29A is giving some sort of flexibility. Therefore, if the flexibility can be used by the parties, then retrospective application is fine. Now, there is a contradictory decision, not on this point, but on the application of 2019 amendment given by Bombay High Court. Now, that case related to use of the Bombay High Court decision basically is on challenge to an arbitral award, section 34. There, when the question application of 2019 Amendment Act was raised, the court held that as on the date of amendment, cases had been filed before that, there would be no application of the 2019 Amendment Act to that.
Pooja, there's a little bit of a disturbance at your end.
My order. Hello.
No, you aren't. It's very faint.
So I think there is someone's microphone has been bagged.
Just give me a sec. Check.
Hello.
Okay, continue.
Yeah. So basically, as on date, we don't have clarity on what will be the impact on applications or petitions pending under Section 11. But one thing which is clear, logically speaking, is that if there's a procedural impact, maybe courts will allow a retrospective application, but that will also depend on how much disadvantage will it cause generally to the ongoing proceedings. That is also something which will weigh in the minds of judges while they decide on this aspect. Secondly, we don't have any sort of arbitral institution which have been designated till date. The rules for grading such institutions haven't been formulated. So until the point in time these come in place, we will still be guided by what was the situation prior to the 2019 amendment. Of course, we'll have to file applications before the Supreme Court in case of an international commercial arbitration and before High Court or District Court, depending on the jurisdiction, original civil jurisdiction. So until the time we don't have arbitral institutions, we still are safe in terms of how we apply the law. But once they come into place, maybe there can be some bit of back and forth in terms of interpreting the provisions. Any questions on this specific aspect? Okay, we can move ahead. Okay, so this is the last part of presentation, but also quite interesting. Both the presenters personally feel, and it's a little interesting in terms of how non-signatories, the jurisprudence lately has been towards including non-signatories if there is satisfaction of 2 or 3 theories which the courts have propounded over time. So before going into that, first thing is the section under which preliminary jurisdictional challenge can be brought before the arbitral tribunal. The governing section is section 16. Basically, the section governs competence of arbitral tribunal to rule on its own jurisdiction, and what all challenges can be raised before an arbitral tribunal under section 16 is what we'll cover here. First and foremost, existence or validity of an arbitration agreement is something which should be challenged under a section 16 application. Jurisdiction and maintainability of the arbitration, the statement of claim is something which needs to be challenged under section 16 application. And under section 16(5), sorry, before going into that, the arbitral tribunal also has powers to see whether it's exceeding its scope of authority. And that is something also which needs to be addressed right at the beginning before even initiating, before even filing the statement of defense. If a respondent has to take these defense, it has to be done prior to that. So what section 16 says is that right at the first moment when a party is aware that there are lacuna in terms of whether the arbitral tribunal has the proper jurisdiction or it is exceeding the authority in terms of its jurisdiction, it has to be raised at the first instance, and there shouldn't be delay in terms of raising an application under section 16. while the application should be raised ideally before filing of statement of defense, but the section doesn't debar parties from raising jurisprudential questions, jurisdictional challenges even after that. So section 16 clause 5 basically says that if there's a challenge under section 16 by the respondent, now the arbitral tribunal can either allow the challenge or it can reject the challenge. In the event the challenge is rejected and the arbitral tribunal is of the view that it has the necessary jurisdiction and the arbitration proceedings are maintainable, that is something which cannot be challenged by the respondent before court under a section 34 application, and the arbitral proceedings will continue. Such an order can only be subjected to challenge after the final award has been passed by the tribunal. But in the event the arbitral tribunal holds in favor of such a challenge and writes an order in favor of the respondent stating that it doesn't have any jurisdiction, then that is a ground for challenge right there under section 34 of the Arbitration Act. Moving forward, what can be the issues that can be raised at this point? First and foremost, as I said, validity of an arbitration agreement. Whether the arbitration agreement has been validly entered into, that is something which a tribunal would decide. Second aspect is arbitrability of disputes. Now, what we mean by arbitrability of disputes is something which has been explained very well and, in fact, in detail in the decision of the Supreme Court in Booz Allen and Hamilton versus SBI Home Finance. It's a 2011 decision which came in place prior to the 2015 amendment. Basically, the court has stated that there can be three kinds of issues when we talk about arbitrability of disputes which the party can raise. First, whether the dispute is capable of being settled or adjudicated upon by choice of a private forum or an arbitration tribunal. Now, this essentially is a question which will govern the jurisprudential aspects of jus in rem and jus in personam. Now, what is the concept behind jus in personam and jus in rem? First, the judgment in rem concept is again linked to right in rem, which is basically right against the whole world. And judgment in personam is basically related to the concept of right in personam, which is against a private entity. Arbitration agreements or arbitration clauses are contractual arrangements with private entities, and arbitration essentially being a creation of contract, the dispute can only be limited to private parties. Therefore, the issues which range in the public domains, say, for example, offenses, criminal offenses committed, or matrimonial disputes in terms of guardianship, or if you talk about testamentary matters, these are rights against the whole world in general, or right in rem, and these cannot be disputes which can be brought into the arbitration forum. So first will be the essence will be to see whether it's something which can be adjudicated by a private forum or not. The second issue which can be raised under arbitrability of a dispute is whether the arbitration agreement has carved out any exception to say that, particular kind of dispute cannot be arbitrated, and there are, say, a set of disputes which can be arbitrated. So if there's no carve out, then of course the principle which will govern is basically that any commercial or contractual dispute which can be taken to a suit can well be arbitrated. The third issue that the tribunal will see and can be raised is whether the parties have referred the dispute to arbitration. An essential aspect of this is, of course, you will read the arbitration agreement, how widely it is worded, what is the scope of the arbitration agreement. And if there's a narrowed scope of agreement of the arbitration agreement, then the tribunal has to limit its jurisdiction within the scope of the arbitration agreement. Now, going into aspects of the disputes which are non-arbitrable. So Booz Allen has listed down a number of cases which fall in the public domain and which specifically are non-arbitrable. As I just pointed out, criminal offenses, testamentary matters, eviction matters, guardianship matters, all of these are non-arbitrable disputes, and it is only because of the jurisprudence based on right in rem and right in person. Now, the concept which was clearly stated in Booz Allen has been propounded further in the case of Ayaswamy versus Paramasivam, which we sort of discussed yesterday also. So what Supreme Court did in Ayaswamy was it sort of extended the list of rights in public domain which cannot be arbitrated, and it has taken a step further to state that matters in the domain of competition or antitrust issue, matters governing serious fraud, insolvency, intellectual property, bribery, corruption, all of these cannot be arbitrated. Now, the Supreme Court has applied two tests why these cannot be arbitrated. First, public domain and private domain, that distinction is there. Second test which it applied is if there is a particular statute which has created a mechanism or has set up a tribunal to assess and deal with particular kind of disputes relating to that domain, then in such situations, such disputes cannot be arbitrated. A classic example here will be disputes pertaining to intellectual property domain. We have specific statutes in place covering trademarks, copyright, patents, and each of these have their specific domains where you will go and take the issue in hand. Say, if copyright registration, you go to Copyright Office and you can challenge before IPAB, for example. Now, these will be disputes which will not be arbitrated because there's specifically a carve out in the statute which allows for an adjudication forum. But what the court did, in fact, there's some sort of ambiguity you'll see when there's a reading of Ayasami and other precedents. So court has stated that because there's a statute separately created, the statute doesn't create a sort of exclusive forum. It doesn't clearly state that exclusively these sort of matters you will take to, say, a particular kind of forum. What it states is that there is a forum where you will take, say, IP disputes, but it doesn't carve out, arbitration. So what Ayasami stated in terms of serious fraud issues is that when there's a serious fraud dispute raised, why serious fraud cannot be arbitrated is because A, it has public concern, public interest concerned. There is a lot of evidence required which needs to be taken in an open forum in terms of a public court proceeding and not in terms of a private proceeding. And there the court carved out and moved aside from this application of the second test where a statute is in place and therefore you shouldn't arbitrate the dispute. There is a conflicting opinion which has come on board from the Bombay High Court where in case of Eros International versus Telemax, so this judgment was delivered a couple of months before Ayasami's decision, and what Bombay High Court did was it sort of digressed from what has been the jurisprudence in Booz Allen and before Eros judgment. It stated for the first time that the entire intellectual property domain cannot be held as beyond the scope of arbitration. Of course, the commercial and contractual disputes pertaining to an IP contract, that will be arbitrable. For example, if there's a movie licensing agreement which has a termination clause and which states that post termination you cannot use the movie for say public display, and if you infringe that clause, this will be a classic example where you can invoke the dispute resolution clause because essentially this is a contractual or commercial dispute and it's not relating to adjudication of rights in the IP domain. So the court has created sort of exclusionary mechanism to show that if there are commercial aspects involved in an IP contract, then you can very well arbitrate. But this is again a Bombay High Court decision and there is no final ruling on this in terms of a Supreme Court decision which will create a precedential value. But this sort of provides a guidance to how people can enter into arbitrations in the case of IP domain. Now, interesting fact here is that internationally it has been accepted that intellectual property disputes can be arbitrated, and rightly speaking, Eros International, Telemax, and also Ayasami's decision, the way the courts reach the conclusion is also in alignment with the international proceedings which allow arbitration of IP disputes. Any question on this aspect? No, okay. So we shall proceed to the next segment, which is basically disputes arising out of non-binding agreements. Shilpa, would you like to continue?
Yeah, thank you, Atmaja. So basically, we're just exploring two specific issues that are raised under Section 16 applications. These are issues of arbitrability that arise out of an agreement that may be a non-binding term sheet or a letter of intent or a memorandum of understanding. And the second issue we'll explore is adding of non-signatories to arbitration proceedings. So in India, the legal position with respect to the bindingness of letters of intent, term sheets, and MOUs is pretty clear that usually in commercial in commercial transactions, parties tend to enter into these instruments and not intend to bind one another. These are just expressions of their intent to further enter into agreements. So usually courts will not hold such documents to be binding, and if there is an arbitration clause in one of these agreements, the extent to which it will bind both the parties will actually depend on the conduct of the parties after the execution of such agreements. The important case here was the case in J.K. Rajgadia, which is a 1995 Supreme Court judgment, where the court held that there will be two factors that ideally any court should look at when it comes to non-binding term sheets or to letters of intent, which is number one, what are the contents of such a document? Have parties agreed on all major aspects that they were supposed to agree on, and have only left out the minute details to be sorted out later? What the court recognized is that in reality, there could be many situations where, let's say in complex construction contracts, you enter into a simpler letter of intent or a simpler term sheet just because you want to get the work started, and you agree to negotiate and sort out the specific details later. But the intent with that particular term sheet or the letter of intent is not to, it's not a subject to a contract document. You do intend to bind yourselves, and your subsequent conduct to proceed with the work that is envisaged under such a document will also bind you to the terms that are set out. However, if the document by itself seems to be lacking and the complete understanding between the parties cannot be derived from such a document, then the courts will look at the second factor, which is the conduct of the parties. And unless and until the conduct of the parties combined with such a document indicates that parties intended to be bound by the contract, an arbitration clause contained under such agreements will not bind parties. Another situation that was envisaged in the case of Dresser Rand was in relation to contracts that are not just non-binding instruments, but have specific language in the contract negativing any contractual intention. So if you have a term sheet which expressly states that it is a non-binding term sheet, the question arose as to whether then can you initiate an arbitration for performance of obligations under such a term sheet and the failure of the other party to perform their set of obligations. There is no judicial pronouncement on this aspect yet, but Dresser Rand seems to indicate that a document which expressly negatives contractual intention will not be upheld by Indian courts. However, there are some international judgments on this, primarily of courts in UK and US. The courts in UK have held that conduct will bind parties even to contracts which expressly negative contractual intention, because by your conduct you waive that condition of non-bindingness or that stipulation in the contract. An interesting proposition that has been arrived at by courts in the US is the courts in US have used a duty to negotiate in good faith to bind parties to contracts that have negative contractual intention and that expressly purport to be non-binding documents. And if the court sees that either one of the parties failed to negotiate in good faith, and that is the reason that the obligations were not performed under that agreement, then that conduct will be held to bind that party which did not act in good faith. Are there any questions? Okay, so I'll move on to adding of non-signatories to arbitration proceedings. So the law
sorry, Shilpa.
Just a
yes.
question.
Yes.
Yes. From a non-binding term sheet perspective, will it be beneficial if we just made the, because a lot of time, okay, this is not related to arbitration, but just to sort of ensure that a document continues to be non-binding, will it be beneficial to just say in the document that it is a contingent term sheet which will come in force once the long form agreement is signed, rather than doing it the other way around, which is capturing the commercial term sheets and then saying that we will enter into a long form within so and so days?
So in India, the position is that number one, just saying that it's a subject to contract document is not enough. If subsequent conduct of the party seems to indicate that sufficient terms were already, reduced in that document and parties had agreed to major terms of their contractual understanding. But if there is specific language in the contract which indicates negative contractual intention, for instance, if you specifically write that this is a non-binding document until and unless long form agreements are entered into, then in India the position is very clear that then courts will not bind you to that document.
Okay. Yes. So it's better to have a negative covenant than a positive one from a drafting perspective.
Yes.
Okay. Thank you.
I have a slightly different question.
Okay.
My question is, assuming it has a negative component, but the arbitration agreement clause or the arbitration or dispute resolution clause, it's an agreement within an agreement. Wouldn't that be? Would that allow either party to take the other party to arbitration, even though the agreement is non-binding?
Yes. So arbitration clause will, though the agreement is not binding, the arbitration clause contained within it, usually just from a drafting perspective, usually parties do state that the arbitration clause will be binding despite the remaining agreement being non-binding. The idea being that even a minor dispute, just to failure to negotiate or confidentiality and things like that, you do want to take to arbitration. But assuming that that's not the case, that you have a non-binding agreement entirely, the arbitration clause within it will continue to survive. You can take the dispute to arbitration, but considering that the dispute is arising out of a non-binding term sheet, whether the dispute is arbitrable or not will depend on how widely worded your arbitration clause is.
Okay, thank you.
Also, just coming in here, at the time when the dispute arises, essentially the claimant in that case, or the party invoking the arbitration clause, will necessarily want to argue that even though the document may say so, but in fact it is not binding. In fact it is binding. So there will be a dispute on whether or not the document itself will be binding or not binding. And that can only be settled through arbitration. So unless there is a clear mandate reflected from the agreement that what the claimant is seeking to enforce is actually not binding, and that only an arbitral tribunal can get into, because it may be a mixed question of law and fact, this would become relevant, because such an argument would be raised perhaps before a Section 11 court. And given the present, the way the law has developed, the court will only have to see whether there's an arbitration agreement, and whether, in terms of the contours of that language of the arbitration clause itself, it is wide enough to encompass even a determination of whether or not this dispute is arbitrable.
So you fall right into the lap of what I wanted to ask. The point is, the minute that happens, shouldn't Section 16 come into fore instead of Section 11?
I agree, but at the end of the day, the determination of Section 16 also would be by the arbitral tribunal. Yeah. So, which is what I'm saying, a Section 11 court, given the jurisprudence that has evolved over a period of time, will restrain itself from making a determination of whether or not to refer the dispute to arbitration. They will say that there is an arbitration clause, it is reasonably widely worded, and there could be a dispute on whether or not this is binding or not binding. I am not going to decide it, because I'm only a reference court. Let all rights and liabilities of the parties are kept open. Let this be determined by the arbitral tribunal itself. And then, as soon as you go before the arbitral tribunal, perhaps the respondent will file a Section 16.
It's a very expensive litigation.
I know, unfortunately it is, but the pros and cons are typically that if your arbitrator is, is reasonably savvy and someone who's able to take a determination quickly, the manner in which it should be then, I think, closed out fairly expeditiously is that Section 16 is clearly going to be raised. But as I said, it could be a mixed question of law and fact. So there will have to be a determination along the lines of a summary judgment procedure, purely on the basis of what the parties have filed. And, you have a quick determination and close it out. Because arbitrators, unfortunately, do have the inkling of even stretching a Section 16 proceedings to over a long period of time. That's one thing that one has to be careful about. But unfortunately, that's how it sort of really plays out.
Solution is worse than the problem.
I agree with you. In those situations, it is. And it is a slippery slope to walk on for a Section 11 court as to whether it should go back to the older situation of actually exercising the judicial mind to determine whether or not this is arbitrable.
That's gone.
I know. That's what I'm saying. So it's a very, we've moved more towards a push to arbitration, and a default position will be to go to arbitration. But there are situations where there may be a very clear case on Section 16, but the court will say, sorry, we can't help it. You go and get it done. That's perhaps the reason why there is that shift to setting up of an institution post the 2019 amendments, which will then be more of a seemingly a clerical task than to really go and knock on the doors and spend money even for the appointment of the arbitrator. It's to be seen as to how that will play out, and maybe there could be challenges even to that. But the intent of the law is to make the process more attuned to alternate dispute resolution. But let's see how it pans out.
Okay.
Just coming in here, so I think to avoid such situations when there's a non-binding term sheet or MOU, it's essential that there's a carve out and you clearly spell out that arbitration clause will not be under the realm of this non-binding agreement, and this will be still applicable. And very important is that your arbitration clause is broadly worded to cover any dispute which may arise in relation to the term sheet, which is specifically called or termed as non-binding.
So rightfully speaking, you are saying that we should go back to Konkan Railways case law jurisprudence.
That's right. I mean, that's one of the ways of looking at it, but clearly against the intent of what the judiciary wants right now.
Yeah, understood.
Yeah.
Are there any more questions? Okay, so we'll move on to adding non-signatories to arbitration proceedings. So since arbitration is essentially a consensual adjudication of disputes, and an arbitral tribunal is a creation of the consensual intent of parties in their arbitration agreement, the question that arises is whether you can force or ask third parties who are not parties to such an arbitration agreement and bring them into the ambit of the decision of the arbitral tribunal and ask them to submit themselves to the jurisdiction of such an arbitral tribunal. And the law in India prior to 2013 was that you can't. The primary decision on this was the decision of the Supreme Court in Sukanya Holdings, where the Supreme Court was adjudicating a Section 8 application. And while doing so, the Supreme Court held that since Section 8 specifically refers to the referral to arbitration of parties to an arbitration agreement, and party was defined very restrictively, that's why you cannot refer non-signatories to arbitration, because the power simply isn't there. The court also took a very restrictive interpretation of Section 7 and read it to mean that there is no power beyond Section 7 for an arbitration agreement to be referred to arbitration, and it does not envisage a third party non-signatory coming in and being bound or asserting its rights in an arbitration. This was followed by the Supreme Court in while appointing an arbitrator under Section 11 in Indo-Wind, where again the court held that the subject matter of the subject matter of the arbitration agreement, and the arbitration agreement only binds the parties to an arbitration agreement, and you cannot bring in a third party. Even though in Indowind there was an entity which had the same registered address as the entity who was a party to the arbitration agreement and was clearly just an alter ego of this entity. However, recognizing this fact also, the Supreme Court had held that the power to refer non-signatories to arbitration simply does not exist under the Indian Arbitration and Conciliation Act. This was not in line with what the international position at that time was, because the international position at the time recognized that non-signatories can be arrayed as parties to an arbitration in certain specific circumstances. These circumstances usually arise out of two kind of situations. One is an implied consent theory, which basically propounds that a party who is reasonably expected to be bound by the decision of the arbitral tribunal would impliedly consent to being a party in such an arbitration and can therefore be arrayed as a party to the arbitration. For example, if there is a contract, if there are multiple parties to multiple interlinked contracts, and only one such contract has an arbitration agreement, but the transaction is interlinked, all the parties to all the contracts impliedly consent to being bound by the transaction in its entirety, which is governed by multiple contracts, and then a dispute arising under any one such contract in this sort of interlinked situation, they also understand that that kind of a dispute would impact them as well. So an arbitration arising out of one contract in this situation would also bind other parties and would therefore bring them within the ambit of an arbitral tribunal which is set up under one contract. This is the theory of implied consent. The other theory that was internationally followed was the disregard of corporate personality theory. Basically, this revolves around the involvement of the non-signatory party in the negotiation and performance of an arbitration agreement. For instance, as a businessman, if I am the face of a transaction, if I go ahead and negotiate with another party and my face and my word is the reason why that party enters into the agreement, but then I use my company as the entity with whom the contract is being entered into, later on in the event there is a dispute, I cannot escape liability and I can be separately arrayed, whether as a businessman or whether as a parent entity, to that arbitration, because the idea is that the other party got involved not with the corporate entity which is actually a party to the arbitration agreement, but with the person who negotiated and probably helped in performance of that agreement, which everyone was aware of. There is a lot of interlinking between these two theories, but these were the two major theories internationally that were followed just to array non-signatories to an arbitration proceeding. The defense of the fact basically that a non-signatory is being bound to arbitrate did not change the character of an arbitration from being a consensual adjudication, out-of-court adjudication process, because in each of these instances, the court specifically looks for either express or implied consent of such a non-party or non-signatory, or the fact that they are bound by such an award in any event to bring them into the ambit of the arbitral tribunal. This actually has global application because all the international the institutional arbitration mechanisms such as LCIA, ICC, SIAC, Hong Kong rules, all of them recognize the arraying of non-signatories to arbitration proceedings and separately provide for mechanisms as to how to do this. One of the most well-known cases in international jurisprudence of a non-signatory being arrayed to being arraying itself to an arbitration proceeding, though it was not a party to the arbitration agreement, was the Dow Chemicals award in 1984. This was actually the first instance of the group of companies doctrine being propounded, which I will actually explain a little bit more when I move to the Indian jurisprudence, which has followed that recently. But what is interesting in Dow Chemicals was that in Dow Chemicals, it was the claimant who was not a party to the arbitration agreement. It was the subsidiaries of the claimant which were parties, and the claimant brought an action against the respondent on behalf of all of its subsidiaries, and was held to be competent to do so on account of the fact that they were all a group of companies, and that the performance of this contract was being done by the group as a whole. I'll just move on to the Indian jurisprudence in and the case of Chloro Controls versus Severn Trent Water Purification Inc. in 2013, which followed this group of companies doctrine and sort of try to explain it a little bit more. But the facts of Chloro were that there was a parent shareholders agreement, and then there were other sub agreements under this parent agreement, which were all part of one composite transaction. And the parent agreement was the agreement which had the arbitration clause, and arbitration was sought to be invoked for failure to perform an obligation under one of the sub agreements. So the question arose, and the sub agreements had different parties, obviously, and not all such parties were parties to the main parent agreement. So the question arose as to whether, in view of the composite nature of the transaction, these companies could all be held to be parties to an arbitration agreement which all of them were not necessarily signatories to. What the court held is that sometimes in an arbitration agreement that's held by one company within a group of companies, there is a sharing of resources. A parent company may use the resources of its subsidiaries to perform its obligations, or vice versa. So, and this could be a factor, a major factor in the respondent entering into such an agreement to utilize the skills of a group as a whole and not just the subsidiary. So because of this factual scenario, and considering that both the performance as well as the obligation was that of the entire group and not just of the single company, regardless of whether they had signed the dotted line or not, all such entities were rightly parties to the arbitration proceedings and should be bound by the award passed therein. So the interesting thing about Chloro Controls is Chloro Controls was a decision passed in an application filed under Section 45, which is a similar provision to Section 8, but applies to international commercial arbitration. At that point in time in 2013, Section 8 did not allow for parties claiming through or under an entity which was a party to an arbitration agreement to seek a reference to arbitration, but Section 45 did have this provision. So the court used this expression, person claiming through or under, to arrive at its conclusion that somebody who is not necessarily a party to an arbitration agreement, but is a person claiming through or under such party, could rightly be arrayed as a party to arbitration proceedings. Subsequent to this decision, a change was brought to the definition of Section 8, to the provision under Section 8 by the 2015 amendment to allow persons claiming through or under a party to an arbitration agreement to file an application under Section 8 as well. Atmaja, do you want to move on to Charan? Hello?
Yes. Shilpa, can you move to the next?
Yes.
So, Charan Properties is a decision of 2018 where the court gave a judgment in and after sort of enforcement stage of an award, and that award was enforced. Basically, the court allowed to enforce the award against non-signatory parties who were not related to the transaction or to the arbitration proceedings. Now, the court went a step further on what was already propounded in chloro control. It relied on international jurisprudence and writings of jurists, including Redfern Hunter, Gary Bond, and how it works in the international sphere, where there is a necessity to bring in third parties to an arbitration or enforce an award against a third party non-signatory. Then court is very well allowed to do so. Now, interestingly, what the court has held in this case is that from the time when Indo-Wind and Sukanya, in fact, it didn't go to Sukanya, but it clearly noted that Indo-Wind was at a time when the international commercial arbitration space had not developed as much, and the commercial contractual transactions which are happening as rampantly as now was not that in case when the Indo-Wind judgment came out. So there's a lot of time lapse since the Indo-Wind decision was written, and therefore both the decisions, basically Indo-Wind and Sukanya, were prior to chloro controls. Chloro controls clearly has observed that ordinarily when an arbitration is entered between two parties, non-signatories shouldn't be allowed to enter into that arbitration. That is the ordinary practice. However, when there are specific theories such as the group company doctrine applied, or there is the theory of principal agent relationship applied, or the beneficiary theory applied, then in these specific situations, the courts can allow arraignment of non-signatory parties to the arbitration proceedings. So what the test has been propounded in Cheran Properties, and which is currently being applied in a number of arbitration cases across high courts and also in certain recent decisions of the Supreme Court, is threefold. First, the court will see whether there is existence of a direct relationship with the signatory, whether the non-signatory has a direct relationship with the signatory. And when we talk about a direct relationship, it doesn't mean that when suppose it's a family-run business and there is an internal family dispute, it doesn't mean that you bring in family members and you show that there's a direct relationship or commonality of relationship or the transaction, and therefore you want the family members to be a part of the arbitration proceeding. That is not what the court will see. Direct relationship with the signatory also means in terms of subject matter which is related to the dispute. So the second aspect which the court will see is direct commonality of subject matter. As rightly pointed out in chloro controls, where you have an umbrella agreement and there are multiple sub-agreements under that agreement, or there's a group company parent entity and there are subgroups which have transactions which can be linked to the main subject matter which the parent entity is involved in a dispute in. These are situations where the court will establish that there is a direct commonality of not just relationship but also commonality of subject matter. The third test which the court will see before allowing a non-signatory to be added is that the agreement between parties must be a part of a composite transaction. Say there's a buyout, or there's a buyout of a main company, and there are certain subsidiary holdings which have shareholding in the main company. Now that there is a commonality of the transaction, and the composite transaction as a whole, where the main company's parent entity is being bought out, has an impact. If there's a dispute which arises in relation to that, then that will have an impact on the shareholding of the I think confused. Holding will have shareholding. The holding entity will have shareholding in the subsidiary entities. So subsidiaries entities shareholding will sort of impacted by the main dispute, and this will be a typical situation where group companies doctrine will be triggered, and maybe if parties want the non-signatory third party or the non-signatory subsidiary to be a party, then that can be sort of arranged, and arraignment of the non-signatory party will be allowed by the court. Now, there are a couple of theories which, if not applied in India right now, but has been referred to in the Cheran decision. First, of course, is the direct commonality of subject matter theory. Second, the court will see a principal agency theory. If that can be applied, then that can be a ground for bringing the non-signatory agent, for example, to the transaction. Another situation can be the relationship or the beneficiary relationship which a party may have from the dispute which, say, another entity has. For example, there may be a transaction where a company has to be entirely acquired by the target has to be acquired by the acquiring entity, And there may be shareholders who will have specific stake in the new entity which will be formed, or after post-acquisition, the shareholding in the acquirer company will also vest in the shareholders of the target entity. So these will be situations where a beneficiary aspect can be brought into board to show that there is necessity to array these non-signatories. And lastly, as pointed out by Shilpa, of course, piercing of corporate veil is also another theory which courts can apply while allowing non-signatories to be added into arbitration proceedings. Now, interestingly, the judgments till now have always been on aspect of, say, post award enforcement stage, where an award has been allowed to be enforced against non-signatory respondent, or it has been on the scope of a section 45 application, or on in relation to whether section 8 can apply and extend to non-signatories. There is no decision currently on sort of jurisprudence on whether an arbitration can begin right from the beginning, can have non-signatory parties on board, and whether they can be a part of the statement of claim. Interestingly, when we are currently doing an arbitration where a section 16 application was filed challenging arraignment of non-signatories right at the filing stage of a statement of claim, but the initial order of the tribunal has been in favor of such arraignment because there are merits in the case which the tribunal thinks is important, and it needs to go into merits to determine whether at the end an award will be passed in favor of such non-signatories or not.
Just before we move on, Atmaja, I think we can just show everyone the list that Professor William W. Park has sort of illustratively said of cases that could be, subject to non-party signatories being arrayed. I'll just share my screen on that for a minute. So what is really interesting is that Professor William W. Park, who is a professor at the Boston University School of Law and is a very prominent commentator on international arbitral law, has written this paper, and he has jotted down 5 scenarios where an arbitrator will likely allow the arraignment of a non-signatory. These are where there is a non-signatory participation in contract formation, sometimes linked to confusion created by mention of the non-signatory in contract documents. So this is a situation where you may have a term sheet for possibly acquiring an entity, and you mention the target probably subsidiary entities within the agreement. You mention who are the possible shareholders who are going to now have a shareholding within your entity by virtue of the acquisition. And all of these entities, like the subsidiaries, the shareholders, just by virtue of being mentioned in the contract documents, do retain a right to then be arrayed as parties to the arbitration despite being non-signatories to the arbitration agreement. Second is a single contract scheme constituted by multiple documents, which is the case that was there in chloro controls. Third is where there is an implied or express acceptance of the arbitration agreement by the non-signatory, whether in the particular arbitration itself or in another forum. This is reduced to law in Section 7 of the Indian Arbitration Act, which says that an arbitration agreement can be found even if there is an assertion of an arbitration agreement in a statement of claim, which is not denied by the respondent in its statement of defense. Then there is absence of the signatory corporate personality, and fraud or fraud-like abuse of the corporate form, which is the piercing of the corporate veil theory, which Atma just spoke about. Atmaja?
Yeah, so in the last segment, we have set out some tips that every party should remember while they enter into an arbitration agreement and while they invoke the arbitration clause in the agreement. It's basically a summary of what we have discussed till now. First and foremost, of course, draft the arbitration clause with a lot of caution and keep as many safeguards possible, word it as widely as possible. In case of non-binding term sheets that parties enter into, keep that severability in place and carve out a clause which states that non-binding term sheet aspect is not related to arbitration clause. So these are certain things that parties need to keep in mind while entering in, while culling out the arbitration clause in a particular agreement. The second point is, of course, determine this dispute right at the first instance when there's a dispute arising, right before even invoking the arbitration by sending a section 21 notice. You need to be clear with what is your claim going to be, who will be the claimants and who will be the respondents, and accordingly a notice has to be served on all respondents individually. And maybe you can take a power of attorney, or you can have the same lawyer who can serve the notice on behalf of all the claimants, and set out basically what the dispute is, give a brief background of the dispute, and if possible the claim amount put in the notice, then it satisfies all the requirements as given in ALUTRO as we discussed yesterday. Third point to keep in mind is, as I have already covered parties to the arbitration. That's a very important aspect, because quite often what happens is, at the stage of sending a notice, if we are not certain of who shall be the claimant or who shall be the respondent, then later on at section 11 or section 16 stage, these can be impediments which will sort of, if not completely oust the arbitral tribunal's jurisdiction, but delay the process of the arbitration proceeding. Issue notice, I've covered that aspect. Okay. The best approach, of course, has to be to appoint an arbitrator of expertise who has knowledge in the specific domain that the dispute covers, and that is probably the win-win situation for the respondent and claimant, because you don't have to go into a section 11 case, you don't have to go into the legal interpretation aspects, and it's sorted and your arbitration kickstarts quickly. Any questions, if anyone has, please feel free to ask.
Almaja and Shilpa, you did mention briefly about the aspect of arbitrability of an intellectual property dispute, but have you gone into the specifics of that and the two Bombay High Court judgments relating to that?
I have covered Eros international decision. The other one I haven't covered, so you can maybe throw some light on that.
So there is, of course, there's Thermax and there is IPRS.
So Eros versus Thermax is the one I've covered.
Correct, you've covered that.
Yes.
That's the one that said that you can have.
Correct. A part of the IP dispute can be arbitrated if it relates to commercial or contractual aspect.
Yeah. Now the thing is, the same court, that was Justice Patel who had given the judgment in Telemax, Eros versus Telemax. So the same court, Justice Dhanuka, he came to a different conclusion in IPRS versus Entertainment Network, where but he distinguished the IPRS case from that of Telemax, because he said that in the IPRS case, the reason for the dispute was whether or not IPRS has a right at all as a matter of law to try and collect royalties. At the end of the day, it depends upon, it is going to be a question of enforcement of their rights in rem. Any third party could tomorrow, in the event that the arbitral tribunal gives a determination of finding on law that that IPRS does not have any right in this, the impact of that could be felt at a much wider sort of domain, because then every third party who's not a party to this arbitration could perhaps look at this particular determination and seek to rely upon it, and IPRS will find it difficult then to enforce its rights. So that's why it's said that when you have, even in relation to IP disputes, a in rem perspective to it, which is what I think you guys had highlighted earlier as well, then it will be difficult to take that or adjudicate that dispute through arbitration or ADR. But when it is a question of pure private contract, maybe there's a licensing agreement, there is a term of a license that is getting impacted, which is purely a commercial, bipartite sort of issue, then arbitration can be resorted to. But that's the distinction that was brought about in these cases.
So you mean to tell that if I have signed up as a company, signed up with IPRS, and then IPRS and I agree for an arbitration, that is okay. But if I haven't signed up with IPRS and there is a copyright violation of say payment of royalty, then because the case comes under 51 of the Copyright Act, there's an action against REM, that won't be covered by arbitration.
In fact, in the case that I was referring to, there was a contract executed between Entertainment Network India Limited and IPRS, which had an arbitration clause.
Correct.
So that contract was sought to be, terminated on the ground inter alia of misrepresentation on law, mistake on law, and also in terms of the fact that the ENIL took the ground that IPRS did not have the right to claim any monies from it. So whereas there was an independent proceedings pending in court where IPRS sued ENIL post termination of for copyright infringement for continuing to play their songs, the arbitral tribunal was concerned with the claim by ENIL that whatever monies they had paid to IPRS prior to termination ought to be refunded to them. So even though the scope of the dispute before the arbitral tribunal was a limited one, however, Justice Dhanuka came to the conclusion that if I have to decide the issue of whether or not the money has to be refunded, the arbitral tribunal will have to first decide the issue as to whether or not the IPRS has any rights at all to have claimed this money in the first instance, which is more a subject matter which has an in rem consequence.
Yeah,
and
I remember having this conversation with Eros Now legal head also when we were trying to enter into a contract with them, and he was trying to give me the background of this one. At that point of time, and I'm talking about 4 years ago now, 4 years ago. This seems to be quite a new case as such. How old is this case now? I haven't followed up in the Bombay High Court.
The ENIL versus IPRS?
Yeah.
This judgment, if I'm not mistaken, is 2016.
Yeah. So just before that, so we had a negotiation with them early 2016. So precisely that's why the situation was, we didn't know the outcome of the decision at the point of negotiation, but yes, this was debated. So the situation at that time was even, because of there was no copyright society in 4 at that point of time. Both the applications are pending. So those were the situations then.
Correct.
16. So it was a gray area of law at that time. That's why I wanted to double check with you. Has that situation changed? I haven't followed it up as such.
No, so the gray area in terms of whether or not IPRS continues to have any right.
No, it's not there anymore. That's November 2017. They got that registration certificate under 33. So they became a copyright society as such.
No, so that they did. But, one of the earlier sessions that we had, maybe about a week, 10 days ago, where we went into a jurisprudential analysis of the amendments, and it is at least my view that position is still not settled, whereas IPRS may have been re-registered in November 2017, which registration was confirmed in 2018. However, whether or not the amendments have altered the position of law as expounded in 77 and further upheld, sort of followed by the Delhi High Court in 2011, Bombay High Court in 2011, and then again by the Supreme Court in 2016. Whether that position really has changed or not is still an arguable proposition. And in fact, we are involved in a case that is pending before the Bombay High Court where this exact question of what is the situation post amendments will be decided. So
just one argument for you in your favor. IPRS is a company, not an association of person under 33. The license cannot be issued.
Correct. So they are taking the stand that they are a company limited by guarantee and therefore akin to that. But more importantly, I think our case is getting into the further detail of whether or not their members, the authors and composers, whether those people themselves retain any right after being engaged by a producer while making of a film for such right to be then assigned to any third party, because it's only when there is an assignment does the issue of payment of royalty comes up under 18 and 19. So I'm arguing that because the law has not changed, the amendment has not been brought about in 14.
Oh, but the government affidavit is there in Bombay High Court, very clearly stating what all cinematographic content or music content royalty is payable.
I know that, but I mean, that's the government's stand because they are trying to bring about a perspective to what the amendments brought about.
Yeah.
That argument to a producer of a film and someone claiming through a producer of a film still remains. The argument is this: Section 14, which is the fountainhead of all rights under the Copyright Act, that provision has not been amended.
Okay.
What has been amended is two provisos have been inserted into 18 and subsection 9 and subsection 10 have been introduced to 19, ostensibly giving a right of royalty, which is separate and distinct from the rights under 14. So the argument of IPRS is that, first of all, they are arguing twofold. One, they are saying that even though the Supreme Court in 2016 upheld the orders of the Delhi High Court, however, Justice, I think it was Justice Prafulla Pant and Justice Gogoi. So they said Justice Gogoi says nothing in this decision of the Supreme Court will be treated as a precedent in law. So they're arguing that this position of whether or not anything was payable even till 2012 is still not settled. That's their first argument. Their second argument is, even assuming without conceding that we did not have any rights until 2012, post 2012, there is this right of royalty which is set out under 18 and 19, pursuant to which we need to get monies collected on behalf of our members. And they are taking the argument that the position of law as expounded by the Supreme Court in 77 has been diluted because of a new proviso that has been inserted at the end of section 17. And that proviso preserves the rights of the authors. If that preserves the right of the authors, that right then gets translated into the right of royalty, which cannot be assigned in any manner. And therefore that money needs to come to the authors composers. Our argument is that when you see the language of section 17 proviso, the new proviso that's been inserted, in terms of effect and consequence, there is nothing different from the language of section 13.4. 13.4 has been interpreted by Supreme Court to say that it must be read harmoniously with 14, and that therefore that position of law has not changed either. And when at the time of creation of a musical work and lyric for a film, at that time itself, if everything is owned by the producer of the film, there is nothing left in the author-composer to give to IPRS or to any other third party. In which case, if you have got the rights through the sound recording company to play a sound recording on a radio or a television, you do not need to separately take a license from IPRS. But as I said, these are arguments that are pending before the court. And
Abhishek, I think we can have a one-on-one session on this topic because I have a different proposition. Because the Chandigarh High Court, if I remember, gave that radio station in Punjab maybe something like a 2% as royalty fee payable under 31A and settled that issue. Indirectly or directly, I don't know how it was settled.
Yeah, I mean that judgment also, I mean, to my mind, is a little. There's no reasoning given in that sense.
Yeah, it's a convoluted one.
Correct. No, we're happy to discuss this offline as well.
Sure. Thank you.
Any other questions? Okay, I think seemingly we've perhaps been able to address the aspects fairly clearly. So in the event, of course, as we always say, if you have any queries that you come up with or think about later on, whether related to this topic or otherwise, very happy to sort of address them. And the email addresses were provided at the end of the presentation. Because one of the queries that had come to us recently, we are recording each of these sessions. We're in the process of collating all the recordings, and we will have those uploaded onto our website, tmtlaw.co.in. So hopefully by Monday, Tuesday, we should be able to achieve that. So anyone who may have missed out any of the sessions, please feel free to access those recordings on our website. And thank you so much, all of you, for joining us. Thanks, Atmaja and Shilpa, for the presentation.
Thank you, sir.
We will be resuming our presentations from Wednesday next, because we take a 2-day break on Monday and Tuesday and get back on Wednesday. We'll be discussing new technologies and law-related issues. Thank you.
Thank you.
Thank you, Atmaja, Shilpa.
Thank you.
Thank you.
Thank you.